Article 254 of the Indian Constitution addresses situations where there is a conflict between laws made by Parliament and laws made by state legislatures, particularly when they pertain to matters listed in the Concurrent List. Here's a breakdown of the article. Clause 1. If there is a conflict between a law made by a state legislature and a law made by Parliament on a subject from the Concurrent List, the law made by Parliament will prevail. This applies to laws made by Parliament both before and after the state law. The part of the state law that is inconsistent with the parliamentary law will be void. Clause 2. A state law that is inconsistent with an earlier parliamentary law can still prevail within that state if the state law is on a matter from the Concurrent List. It has been reserved for the consideration of the President and the President has given his assent. Proviso, however, even after the President's assent to the state law, Parliament retains the power to make a new law on the same subject that can override or amend the state law. Summary. Parliament's law generally takes precedence over state laws on matters in the Concurrent List, but there's an exception if the state law receives the President's assent. Even when a state law prevails due to presidential assent, Parliament can still later make a law that overrides the state law. The Constitution of India. Part 11. Relations between the Union and the States. Chapter 1. Legislative Relations. Distribution of legislative powers. Article 254. Inconsistency between laws made by Parliament and laws made by the Legislatures of States. 1. If any provision of a law made by the legislature of a state is repugnant to any provision of a law made by Parliament which Parliament is competent to enact, or to any provision of an existing law with respect to one of the matters enumerated in the Concurrent List, then, subject to the provisions of Clause 2, the law made by Parliament, whether passed before or after the law made by the legislature of such state, or, as the case may be, the existing law, shall prevail and the law made by the legislature of the state shall, to the extent of the repugnancy, be void. 2. Where a law made by the legislature of a state with respect to one of the matters enumerated in the Concurrent List contains any provision repugnant to the provisions of an earlier law made by Parliament or an existing law with respect to that matter, then, the law so made by the legislature of such state shall, if it has been reserved for the consideration of the President and has received his assent, prevail in that state. Provided that nothing in this clause shall prevent Parliament from enacting at any time any law with respect to the same matter including a law adding to, amending, varying or repealing the law so made by the legislature of the state.